Welcome to today's Expert Voices session being hosted by the Centre for Justice Innovation. It's the first one of 2026, so it's lovely to see so many people being able to join us today. Today, we're going to be shining a light on the experiences of litigants in person, those accessing our justice system without legal representation. And we're also going to be focusing on one of the services that is available to support them, CAS Plus, an advice and support service in Devon and Cornwall. Just a few bits of housekeeping as we are letting the last few attendees in. You will notice that your cameras and your mics have been automatically turned off. This is so there's no interruptions to the speakers, but you will also see that the Q&A section of Teams is open, and I am going to encourage you to please do send through any questions or queries, as we are hoping to have a section for questions and answers at the end. The event is being recorded, so that is already taking place. So, oh no, we've got a few more coming through. Bear with us. Let's see. Okay. Well, as the last few are coming through, I will just start by saying a little bit about the Centre for Justice Innovation, for those of you who are not so familiar with this. We're a not-for-profit organisation that seeks to build a justice system that is considered fair and effective by all of those who are using it or taking part in it. We believe the system should be focusing on solving the issues that drive the difficulties people face, and that it should be fair in how it is treating everyone that is coming in contact with it. As an organisation, we deliver a range of work to support that vision. We provide hands-on support to practitioners. We conduct research into how things are working and how they could work better in the future. And we really do promote what we like to say is evidence-based and innovative justice policy reforms. And I would say that our Expert Voices series is really at the heart of this approach. And we've done numerous sessions on various topics across criminal and family justice, and all of these are available on YouTube, and this one will also be available on there shortly afterwards. These events are free, they're open to absolutely everyone, so please do share about them. We're aiming for them to be as accessible as possible to anybody who wants to join on from a range of backgrounds or prior understanding of the topics being covered. It's part of a much wider kind of programme of work that we do, where we're really promoting the voices of both practitioners, academics, those of lived experience who are leading on or having to experience the kind of crucial issues that we're talking about day to day. Okay, so the beeps have stopped. So we will come on to the main topics of conversations. Miranda, just as I said, the beeps have stopped, they just start again. Miranda, if we could have the next slide, please. Yes, fantastic, thank you. So today's event, we're actually going to be drawing on the evaluation from the Centre for Justice and the Wilkinson evaluation team of the work that CAS Plus service has been doing. We're going to be exploring the barriers facing litigants in person, the impact on the individuals involved and the wider system, and really how CAS Plus has sought to support them. So to discuss this, we are really pleased to be joined by Stephen Whitehead, our Head of Data and Evidence from CGI, who is part of the evaluation team. From CAS Plus, we are joined by Steve Parker, the CEO of the organisation, and CAS Plus coordinator Emma Stewart, and you'll be hearing from them a little bit later on in today's session. And we're also really pleased to be joined by Jude Eyre, Associate Director for Strategy and Delivery for the Nuffield Family Justice Observatory. And Jude, I'm actually going to come to you first, if that's okay, to speak to us and set the scene, really, to tell us a little bit more about those kind of characteristics, experiences, the demographics of who we're actually seeing coming into our courts and those that are litigants in person in the system. So I'll hand over to you. Thank you so much, Jude.
Thanks, Sophie. Thank you so much for having me here. I'm really pleased to be able to join and talk about this, and I'm really looking forward to hearing more about CAS Plus and the service and the evaluation there. So my name's Jude, and I'm an Associate Director at the Nuffield Family Justice Observatory. The observatory is part of the Nuffield Foundation, which is an independent charitable foundation which largely funds research. And it set up the observatory about 7 years ago to be a bridge between that research and evidence and practice in the family courts, with the aim of improving the lives of children and families who engage with the family courts. So today we're going to be talking about private law proceedings, which, as many of you will know, are situations where adults are making applications to the family courts for orders relating to where children should live or who they should see. So very commonly, but not always, separating parents. And what I'm going to talk about is what we know from the wider evidence base about the situations those adults are in their lives when they come before the court and their experiences of the court. And I've only got 10 minutes, so it's going to be an absolute whistle-stop tour, but I hope this will be a helpful background before we get on to the detail of what the CAS Plus service is all about. So can I have the next slide, please? So this slide, you can see the picture there, which is the front cover of a report we published in 2023, which was a spotlight looking at all the available evidence at the time on the experiences of adults in private law proceedings. And my colleague, Alia Said-Tezier, came up with 7 key messages from that evidence base. So I'm going to speak through each of them in turn. And the first one is about court being a last resort for separating families. Now, the evidence from people who do go to court and don't go to court tells a fairly consistent story of the fact that people didn't really want to go to court. And that perhaps explains why most people don't, because 90% of families who separate and make arrangements for their children don't use the court to do that. So there's only 10% who do. And people talk about why they don't want to go to court in terms of wanting to thinking it's going to be a stressful, negative experience. That it will be expensive, and that it can further damage what was already a difficult relationship, that it might up the ante. So I think it's important to understand that usually when people are in court, there is no place they would rather have avoided. They really, really don't want to be there. The second lesson for us is around the kinds of financial circumstances that families find themselves in. I think often when people think about private law, they think about perhaps very wealthy families who have limitless assets to spend on legal teams. That is not the demographic of the average family in private law. We know that more than half of families involved in private law proceedings live in the most deprived areas of the country, what we call the bottom 2 quintiles, the bottom 40%. And so deprivation is a really important factor in their lives generally, in terms of the challenges and struggles that people are facing in everyday life, but also in terms of how they interact with our systems and processes, people's ability to access paid for services, whether that's legal advice, whether that's things like supervised contact or drug testing, the kinds of things that can sometimes come up within proceedings. So that can be a real challenge. The third message is a sort of new emerging message around the ethnicity of those involved in private law proceedings. And we didn't know very much about this until a couple of years ago, when a team from the University of Lancaster and Swansea looked at the data and found that there's an overrepresentation of families from some ethnicities, particularly Black families and families of mixed ethnicity. That overrepresentation holds whether you're in an area which is already very diverse. They are overrepresented within the court population there, but also for areas which might not have that general population level diversity, there is still an overrepresentation. And we don't really know very much yet about the reasons for that, or indeed the outcomes of that. What does that mean for people's experiences as they go through the system? Some of the evidence around people's experiences of domestic abuse when they come from a minority ethnic family talks about stereotyping and bias and how families felt that influenced their experiences. So that's something that's important for us to understand. In terms of the fourth message, I said that normally we talk about separating parents, but about 10% of applications to private law aren't about separating parents, or at least they involve an adult who is not a parent. And the largest group of this is in relation to kinship care applications. So situations where children are being cared for by other family members or friends, and the court is being asked to formalise that arrangement or regulate that arrangement. And the context to those sorts of situations have a lot of similarities with the context that you might associate with social care intervention, public law, care proceedings, but they are being dealt with through the private law system. And that poses real challenges because in public law, you have automatic legal aid for parties, you have separate representation for the child, you have an infrastructure that is built around those kinds of complicated and difficult issues, which is not replicated in private law proceedings. The fifth issue is around health issue, and we published some research a few years ago now, again from the University of Lancaster and Swansea, Dr. Linda Cusworth and her team, where they looked at linking health data to court data, and they did that in Wales, where they can do that through an anonymised data linkage. And they found that families involved in private law proceedings were had 2 to 3 times higher levels of particularly mental health difficulties than a comparable same age population. So we're talking about anxiety, depression, but also schizophrenia, bipolar disorder, 4 to 5 times levels higher for self-harm. So some really significant issues for families. And this was at the point when they were coming into proceedings. So this is before they've actually engaged with what we know can be a really stressful and difficult time. The sixth message here is around domestic abuse. Now, this is, I would say, probably the best evidenced area in terms of the experiences of families and private law courts. And the most up-to-date evidence, in fact, because the Domestic Abuse Commissioner's Office, Mandy Burton, Rosemary Hunter and team published a report on this at the end of last year. That report is called Everyday Business. And the reason it's called Everyday Business is because they found that somewhere between 80 to 90% of cases in the family courts for private law proceedings have issues of domestic abuse raised within them. It's absolutely standard and commonplace, and that can have really significant impacts in terms of people's experience of coming to court with somebody who they may have experienced abuse from, and also in terms of the court's decision making, the vital importance of it making safe decisions. So then finally, moving on to the last message, which is particularly pertinent as we go on to the CAS service, the rates of adults representing themselves in private law proceedings is growing. And if we can have the next slide. This has been a continued trend since 2013, when there was a change in the law to the eligibility for legal aid. I don't know if my next slide is coming. I'll keep going anyway. Which has seen a really dramatic change in the levels of representation within the court. So now we have a situation where around 80% of cases nationally feature at least one person representing themselves, and over 40% of cases, actually slightly increased since these figures, now includes no representation at all for either party. So what does that mean in practice? Well, there's a good evidence base in terms of what family members have told us about their experience of that. And sadly, it is a very negative experience. People talk about fear and anxiety. They talk about confusion and marginalisation. They talk a lot about this frustration with this slow, time-consuming process, these things that take a long time, but without any clarity about what they are or when they might come to an end. People talk about really not understanding the very basics of what's going on. The language being used being really exclusionary, and stopping them from feeling like they can actually take part in what is a decision about their family's life. So it can be a really, really challenging journey for litigants in person, people representing themselves. And we know that that is, again, a majority experience now within the courts, that at least somebody is representing themselves. So my final slide is about something new in the world of family law, well, new-ish now, a new way of doing private law proceedings, which I think they are finding a new name, but for now, everybody still calls Pathfinder. And this launched in 2022. It's a Ministry of Justice led initiative, which looked at delivering private law proceedings in a different way. And it's now in, I think it's 8 or maybe 9, depending on how you count it, areas, including Dorset and Hampshire, so some geographical proximity here. The model was designed with an understanding of where we are in terms of how many people have to engage with this system without representation. And therefore, there are some elements baked into it which are designed to try and mitigate some of the impacts of that. So first of all, there's more social work input up front, something called a child impact report, where Cafcass or Cafcass Cymru in Wales, or the local authority, if they're already involved, meets with the parents or the other family members, meets with the child, which is quite a significant change in the model, before anybody stepped foot in court, to do some quite in-depth work talking to people about what is happening in their lives and what they would like the court to do. So the idea there is that we're placing less focus on people filling in the application form in a way which is going to guide the court, or expectation that lawyers are going to be there to make people's cases for them, but trying to have a sort of holistic report from the beginning that might capture some of that information and allow people to talk to that when they do come to court. There's inbuilt support from domestic abuse agencies. As I've said, domestic abuse is a very significant issue for families involved in private law, and the Pathfinder model seeks to find early opportunities for families to be referred to specialist support services, specialist risk assessments, and ongoing support in court if they need that. There's a new role called the Case Progression Officer, who is within the court office team, and they do really sensible things like ringing people up when they've sent in an application to say, do you understand what's happening? Do you know what you've been asked to do? If there are directions from the court, do you understand what those are? That's had some really positive feedback in terms of supporting people to understand what's going on. And then finally, just a general focus on the language and accessibility, hearing that message that if we have a court process steeped in legal language and you are not a lawyer, it is not a process you will understand, and that the onus is on the system to change, not on the people using it. So those are the intentions of Pathfinder. I've had lots of positive feedback. There's some evaluations which CJI and others have been involved in, but I think it is fair to say that that model cannot be the antidote to the very wide-ranging and deep-seated issues that people have told us about in terms of their experiences of being self-represented parties. So there's within that evaluation evidence, there's still expressions of some difficulty around self-representation. And so I think it's a particularly important time to be talking about what kind of models of support we might see on an ongoing basis, because Pathfinder may offer lots of opportunities, but I don't think anybody involved in it is suggesting that it is the answer to everything. So I'll hand back to you, Sophie.
Oh, thank you so much, Jude. Really appreciate it. I'm going to welcome Steve and Emma now from CAS Plus. I'm sure they'll be agreeing very much with everything that you have shared so far today. So if we can jump into the first slide of Steve's presentation. Steve, Emma, over to yourself.
Yeah, thank you very much, Sophie, and thank you for the invite to speak today. I'm Steve Parker, as been mentioned. I'm the CEO of CAS Plus, have been made for 18 months, and we're really privileged to have our founder, our ex-CEO, Carol Edwards, who started this project. She's in the meeting today, so it's nice to see her amongst the names who are with us. I'm just going to start off by doing a quick introduction to CAS Plus, just what we do, where we've been, and I'm going to hand over to Emma, who's going to provide some detail around case studies that will bring the service to life in this context. So if we could move on to the next slide, please. As you'll see there, CAS Plus was founded in 2005. We're an independent charity. We're a criminal justice focused charity that's located in the magistrates courts across Devon and Cornwall. Our 20th anniversary last year. And we work in the public areas. That's where our offices are located, in the public areas of the magistrates courts, and it's very much a walk-in service, and we provide support to anyone who's in the court system, but primarily it does tend to be defendants and those who have been convicted of offences. We provide emotional and practical support, and we seek to address the underlying issues which impact on people and that bring them into the criminal justice system. And we will support people as long as they need us. That's the model that has always been CAS Plus its way. And we, as well as that, providing that on-the-day support, we also signpost to other agencies, and then we look to support people with interventions and signposting over time. So that's how we used to work. Then if we go to the next slide, you'll see that in 2023, we started a litigants in person project, and we were supported in this from the Access to Justice Foundation through their IOTLS grant funding program. Now, this isn't to say that prior to this CAS Plus, I hadn't had any involvement in family court and litigants in person. The previous advice, though, and support we'd give was very much on a practical day-to-day signposting within the court. There was no specialist knowledge, and as we found out, this is a really complex area. So in 2023, we took on this project and started to think about how we can support people in the family court system. So if we move to the next slide, please. So we initially took the approach of using our existing model, that walk-in model, for supporting people in the family court. Upskilling the team, we found that that was a challenge in terms of identifying training and support that we could get. And we were really grateful actually to local HMCTS, who provided us invaluable support and assistance and really helped us in terms of providing exposure and publicity for our service and signposting. We soon found out, and I'm going to seek not to duplicate what Stephen's going to say in terms of the evaluation, but it's important to say we found there was an incredible demand in the work that we came across and was referred to us, and also significant complexity. And this real complexity that sits in the family court was quite challenging to work our way through. And we were really surprised about that absence of support and legal aid that Jude's referenced. All the things that Jude has referenced in that overview of the family court system is what I found when I joined the organisation and trying to bring myself up to speed. So it really did replicate that. So that's our starting position. Emma's just going to talk through some of the case studies that we've had, and then I'll just summarize what we've done to address what we found as we've gone along. So I'll hand over to you, Emma.
Thank you, Steve. So I'm a coordinator at CAS Plus, and I have a few case studies highlighting the challenges faced by clients we supported through family court. If I can have the next slide, please. So to start with, we met with Alan, who was a father. CAS Plus supported him for 11 months. He was referred to us by other court staff. He was both illiterate and with his ADHD was really struggling to process both verbal and written information during the court process. So we helped Alan draft a position statement, and he really was really thankful to us for helping get all his concerns on paper and have his voice heard before the court. On the morning of his hearing, both parties received a report from the local authority. So we went through this document with Alan, making sure he understood the content, any recommendations, and any questions he might have for the court staff. There were safeguarding concerns for his child following drug and alcohol results. And so following on from this, there was another court hearing, which was changed to a remote link, which Alan was extremely anxious about and came to CAS Plus for emotional support through that and to note take. We also went through his court order before this hearing, highlighting any steps that Alan needed to take and making sure he'd submitted any documents that were required prior to the hearing. There were repeated false allegations in this case that were impacting Alan's mental health. So we did signpost him to support for that to help him navigate this process. He did become eligible for legal aid because of the complex nature of this particular case. And again, we were supporting Alan to complete the paperwork required by the solicitors to obtain that legal aid. It wasn't processed before one of his hearings. So again, we stepped in helping him draft a position statement in response to parenting assessment recommendations. The child was moved to live with Alan. He was deeply thankful for all of our help and felt that result wouldn't have happened without CAS Plus and social services. We did check in with him to find that legal aid was in place to continue the process, and that his child was like a different child. He was happy, secure and thriving. And then we move on to Bridget. So if I can have the next slide, please. So Bridget, we worked with for 8 months. She came to us going through a child arrangements order. She had PTSD from the previous relationship, which involved domestic abuse. She didn't qualify for legal aid due to her husband's income, but had difficulty affording a solicitor. We helped her to compile a schedule of allegations. Now, we were very aware that there was a lot of trauma around this for Bridget. So to minimise that, we took a trauma-informed approach, and we took as much information in the early stages from Bridget that we could, aware that further along the line there might be evidence asked for and a fact-finding. And we were aware of how distressing it was for Bridget to keep going through these difficult memories. She was also trying to do all of this work on her mobile phone, trying to download large court bundles, templates and compile evidence. So we were able to support her to get all these documents and with the admin side ready for court. We also talked through court process. As the other party had a solicitor, we needed to explain to Bridget why they would be meeting with her before the court hearing, and that they were presenting both parties' positions to the court. Bridget found this interaction very intimidating, and she viewed the court process as in favour of those legal representation. We also did a lot of I've disappeared. There we are. We also did a lot of translating legal terminology so she could fully understand the court procedures. At the court hearing, due to delays with reports for both CAFCAS and local authority, the case was adjourned, so it sort of lengthened the process. And then at the next hearing, there was an ongoing investigation with the other party that was to go through criminal court. So again, the case needed to be adjourned, awaiting that outcome. So due to, again, a very complex family case, we did direct Bridget on to legal representation moving forward. And then I come to Caleb, who we worked with for a shorter period of 4 months. He came to us earlier in the process, needing help completing a C100 form and a referral form to the charity advocate, hoping to obtain some legal assistance. So we helped him with the content of those forms and what he needed to do. There was also domestic abuse allegations, which meant that Caleb couldn't see his child at this stage. He was really low, very much struggling, not being in communication with his child, and had trauma related from the past relationship. He couldn't afford the supervised contact centre visits. So CAS+ were able to obtain funding, managed to get hold of £200, which could finance supervised contact for Caleb before the next court hearing. And you could visibly see the difference in Caleb's demeanour and his emotional health and momentum to continue with the court process. We also referred him to Both Parents Matter for him to get some peer support and understand each step of the court process and feel more informed and more empowered. Again, his court hearing was switched to remote. And again, there was a lot of anxiety around that. So we did emotionally support him. Again, when we started working with the family courts, we quickly found we didn't have the capacity to do all the in-court support. So moving forward, we were advising clients about the opportunity to request a Mackenzie friend for that emotional support and note-taking help during what's a very stressful and anxious time for them in these hearings. His particular case, drug and alcohol testing was required. Fortunately, mother had legal aid, so the fees were covered by her legal aid, but we have supported clients when neither party has legal representation. Drug and alcohol testing is required, and we've seen them needing to adjourn the court case while the parents go and raise the fees, which can be around £700 to £800, which further stresses and delays the resolution for the family. And during this process, advocate came forward saying they were able to represent Caleb, so we were able to close this case on this occasion. And I'm going to hand straight back over to Steve.
Thanks, Emma. And in summary, I just wanted to pull together some of the things that we've learned along the way, some of the changes we've made. So there's an acceptance, and we understand that we can't meet the demand in the family court system. As I've said, it's incredibly complex. We've had people approaching us from across the country seeking our advice, and that understanding we can't meet it with the resources we have has led us to the position where we prioritize vulnerability. So we try to provide advice and support where we can, but we ramp that up and give more advice to those who are the most vulnerable. One of the ways we've approached that is to put in place a self-referral process. So people make a referral into our service, and we triage that away from our frontline teams. And that is actually really, really helpful in terms of giving a real understanding of what people's vulnerability is. It gives us a clue as to their capacity, their access to digital resources, and their ability to engage with the system. So that's really helpful. We still give advice and support to everyone we can, and we provide guides to people where possible in terms of things like if the court is asking for a hair strand test, the actual practicalities about how you get that is really difficult, and people are starting from scratch. So a little bit of guidance in terms of that can really help. But what we've had to do is significantly reduce our in-court support, which has been a difficult process because that's our instinct is to help people as much as we can. But the family court processes are so long, convoluted, take up so much time that we found our resources were completely being devoted to being to a small number of cases and being in the court. So wherever we can, we've reduced that in-court support, and we've focused on empowering clients, giving them the confidence to actually work within the family court. It's true to say that people often, when they get into this part of the justice system, they don't actually have any idea of the processes. The processes aren't usually on television, unlike the criminal justice ones. So everyone's starting from scratch in terms of those processes. And we have people who don't think they're able to represent themselves within family court, and so they're looking that they've got to have a solicitor, and they find themselves really wrong-footed when they're asked to represent themselves, and also explaining some of the procedural elements and the way the court works, particularly when you've got legal aid for one party and not for another. So that's the approach we've taken in order to position ourselves going forward. I would end by saying this work is really, really rewarding. There is clearly a need for people to be supported in the family court, and I know the teams take a lot of pride in the way they're able to support some of the most vulnerable in society and get them to appropriate court resolutions and support them through that. So while it has its difficulties, it's also a positive service that we're providing. And I'm going to hand over to you, Stephen, for your next bit. Sorry, Sophie.
Oh, no, it's not a problem. I was just going to say thank you so much for that. And those case study examples really bring to light the complexities that families, parents are facing. So Stephen, bring you in now. Let's hear about the evaluation and work you completed. And I think you are on mute.
That was predictable, wasn't it? So thanks, Sophie, and thanks also to Jude, Steve and Emma for everything they've said so far. So I'm going to talk a bit more about this evaluation that we've undertaken, which was funded by the Access to Justice Foundation as part of their funding to CAS+. And this is something that the Centre for Justice Innovation did in partnership with Wilkinson Evaluation and Tina Wilkinson, a locally based evaluator who spent hours and days with the service, with clients, with staff, and really got under the skin. And Tina can't unfortunately be here today, but I'm going to try and represent her finding as well as my own as much as I can. So in the next slide, we should be able to see a brief overview of the scope, and I've carefully marked with the logo of the bits that Wilkinson and Tina led on. But briefly, our evaluation was kind of a combination of an implementation and an outcomes evaluation. It sought to understand the need for the service, who it supports, how it supports them, and the impacts that are achieved in both clients and the wider court system, and importantly, what lessons we can learn for policy broadly and for practice locally from the process of implementing this service. So we spoke to CAS Plus staff, we spoke to judges, we observed service delivery, and we looked at client data as well as a client survey to do this. So moving on, I'm going to start by talking a little bit about, on the next slide, just the nature of the people coming through CAS Plus. And we using data from the service, identified 390 clients who entered the service between October 2023 and March 2025. 53% male, 47% female, so a fairly even split. And given as what Jude said about the kind of high levels of domestic abuse allegations within private family law, we can see that the male client base there is definitely going to include some people against whom allegations of domestic abuse has been made. Almost all white British, so that's relatively in line with local counties. I think Cornwall 94% white British, Devon 92%, but not seeing the kind of overrepresentation of other ethnicities that we see in the kind of national picture. Kind of quite a broad age range between sort of 25 and 54. So the kinds of ages you expect people to have children under the age of 18. Almost the vast majority of clients in a child arrangements case, the only other kind of regular case types being seen were a limited number of divorce cases or people seeking non-molestation orders. But in terms of the legal status, we did note that people could come in at different points in their journey. People, yes, absolutely were told about CAS Plus at the point when they started their application or they received their kind of first paperwork from the court, and many came in then. But people would also come in further down the line as they started to struggle with the process and realize that they might need more help than they originally envisaged. So next slide. And I think this is really important. I just wanted to make a little note of the specific vulnerabilities that CAS Plus clients face. And this is very much in line with what we've heard from Jude earlier. You can see a full third of clients nearly experience some level of mental health need, and about 1 in 8 experienced learning needs, so probably what we might call SEND in other circumstances, and a similar number of physical need. And we know that having any of these needs will significantly impact people's capacity to participate effectively in the court process, to understand what's expected of them, to represent themselves effectively. These are real barriers. Next slide. So based on the work with clients, speaking to stakeholders in the judiciary and the court service, speaking to CAS Plus staff, we started to build up a picture of what it was that litigants in person are really struggling with when they come to family court. And this really comes across 3 areas. First of all, understanding the court process, as Steve has referenced. There's not a great deal of pre-existing understanding of how private family courts work. As Jude says, we might think of these kind of high-powered divorce cases, but not a lot of knowledge either from friends or from the media about how courts function. And I think that's really compounded by a lack of appropriate and accessible information that's designed for litigants in person. It's not easy to find out how long a case will take, what will happen, what will be expected of you, what the kind of range of likely outcomes are. And this obviously compromises people's ability to participate, but it also creates frustration, anxiety, stress. It makes the process of going through more difficult when you don't know what to expect, either in terms of timelines or processes or outcomes. And kind of related to this, we noticed that litigants in person would really struggle with the things they are asked to do, whether that's filling out forms, which can be quite complex, and particularly if people face kind of specific challenges. And then once they get into the process, complying with directions, whether that's getting a drug test, undertaking supervised contact, getting a letter from a GP, writing a statement of fact, which has to be done in a particular format, and really ought to be restricted to certain kinds of information. All of these, they can be really difficult for people to deliver, makes it difficult to take their case forward, and again is a real contributor to stress and anxiety. And the third point where people really struggle is actually in attending court hearings. People going in on their own would find them very stressful, and that leads to emotional dysregulation, that leads to people behaving badly, kind of outbursts which can not only kind of harm themselves, it can be distressing to other people, it can be difficult for them to manage, certainly difficult for people to kind of represent themselves effectively and get their kind of perspectives across, and difficult for people coming out to understand what's just happened to them, what they're expected to do next. So this is a real different place where people experience difficulty, but particularly when they kind of lack support. So next slide, please. I'm actually going to skip over this one. I think we heard great information from Steve and Emma on how CAS Plus support that works in practice, but if you want to refer back to the theory of change, it is excellent, and I suggest you look at it in the slides. But so this is based on client perspectives, based on stakeholder perspectives, a sense of what difference it makes having this kind of support from CAS Plus. And the first and sort of most obvious is understanding of the court process. CAS Plus workers will take a lot of time taking people through what to expect in terms of processes, timelines, outcomes. And really importantly, they, as independent services, they can do that with a realistic eye to sometimes the shortcomings of the service, when things don't work ideally, when there might be sort of frustrating delays, and what's the reason for this, but also in a way that's kind of sympathetic to people's experiences. And that secondly, the capacity to participate effectively, helping people to know and do the things that are expected of them, to put their perspectives across clearly, to actually feel like they're taking part in their case and have an impact on the outcome. And both of these really fed into a kind of clear sense that the stress and anxiety of participating is reduced significantly, with a feeling of better information, greater confidence, and a feeling of support, of not being alone in the process. And you can really see that in the kind of client perspective there. Fourthly, and I think this is more disputed, this is interesting, there was some suggestion that having CAS Plus in place might address what one of the judges described as an imbalance between represented and unrepresented parties in terms of the likelihood of achieving an outcome that they find satisfactory. And I think that kind of certainly makes intuitive sense, but it was disputed by other judges. If you move forward, we should see a different kind of contrasting quote here, with some judges saying, no, actually, we believe that when there is an unrepresented person, litigant in person, the court will do more work to kind of try and draw out their perspectives, to understand their viewpoints, and is quite effective in redressing the balance already. So I think it's an interesting thing to think about, and it's certainly intuitively plausible, but it's not something that everybody agreed on. And the last thing we saw is a broader set of changes in clients' lives, whether it's about reducing harmful behaviours, whether it's about improved mental health. And we can understand this probably both as a sort of reduced stress and anxiety from CAS Plus, perhaps a greater confidence to access services, perhaps a greater understanding that maybe addressing harmful behaviours is going to be a real asset in pursuing the kind of outcomes you want through family court. So it's not something that necessarily, although in other contexts, we know that CAS Plus has worked directly on those issues. That doesn't seem to be happening so much with family court clients, but it does nonetheless seem to be a basis for change. Moving forward again, to the next slide, please. So we also collected some data specified by the Access to Justice Foundation on people's legal needs at different points in the process. And here we can see two contrasting points. This isn't really a starting and end point. The green columns on the left represent people's levels of need after they'd met with CAS Plus for the first time. So after they'd already been given a kind of probably quite an intensive amount of additional information and advice. And the grey columns on the right are not necessarily the end of the cases, but actually the last point of recording. And we know that at the point that we stopped our data monitoring, a lot of cases were still ongoing. But nonetheless, even between the point where after they've met CAS Plus for the first time and the last point of recording, we can see real change across, well, we can see some improvement across all of these outputs, but real change in a couple of areas in particular. We see a notable growth in the extent to which workers assessed that clients were in control of their situation and able to deal with their problems. That's obviously really positive. And then, as we'd really hope to see, a big growth in the number of clients who over time had their problems resolved and drew to an end. So that we can see some evidence of real change there, although it's probably not capturing the full change from before people see CAS to after they leave altogether. Next slide, please. We also picked up some sense that the work that CAS Plus does really facilitates the work of the court. We saw judges and court staff telling us that they saw far fewer unnecessary adjournments, which were often the case where people would come back to court and they simply hadn't completed the things they were asked to do, hadn't got the test, hadn't got the information, hadn't submitted the statements or whatever. So simply making sure that people were ready for their court hearings reduced adjournments and saved courts quite a lot of time in repeated unnecessary hearings. We also heard people telling us that CAS Plus clients were presenting more and higher quality evidence, which again we might expect, and that makes a difference to potentially not the outcome, as we've heard, although it may be the outcome, but at least the sort of robustness and the level of information that is available to courts when they're making their decisions. And that's obviously very welcome for judges in particular who want to be making decisions on the best quality evidence. And finally, within the hearings themselves, we felt that both people knowing what to expect, having greater confidence, and where they did have a CAS Plus worker with them, having that extra support, really made hearings run more smoothly. There was a big reduction in that kind of volatility, those outbursts, which meant reducing the potential for distress both for clients and for other parties. And I think that's really important, particularly in cases where there are allegations of domestic abuse, where there might be potential power imbalances, where there might be real risk to the kind of feelings of safety of other parties. Just keeping people emotionally regulated and focused on what the court expects of them is actually a kind of benefit to everybody involved. So next slide, please. Just to think a little bit about what we learned from the implementation of CAS Plus. Well, we saw that CAS Plus was coming from outside the family system, was really as well placed as any service could be to deliver this kind of non-legal support. It had lots of partnerships within the courts, lots of relationships with the court service, experience of working with vulnerable people, a broad base of relationships and supporting areas. And yet, despite being a kind of well-placed service, there was quite a steep learning curve as the service moved from supporting people in magistrates' courts who have generally kind of quick and legally non-contentious cases. It will be a single hearing. There's most commonly a guilty plea and a sentence, through to the complexity, the perhaps higher personal stakes, and the kind of length of time of a private family law case. And that meant both greater need for support with the kind of complex procedural legal questions, but also a kind of greater level of emotional and mental health even needs for people coming through. And though for a service that, as I think Steve would have said, has a culture in the magistrates' courts of giving anybody who asks as much help as they need, this was a bit of a shock to the system and actually led to teams becoming kind of quite overwhelmed as they struggled to both develop their ways of working and develop an understanding of the kind of levels of need. And as we've heard, ultimately the service had to sort of move away from the sort of full open door ethos to a kind of more rationed and targeted model. And so just to sort of take that through to the kind of final slide, in terms of reflections, I think we can see this is obviously, these are non-Pathfinder courts, but we can certainly see within those courts that the demands on litigants in person, particularly for vulnerable litigants in person, are unrealistic. It seems like for lots of people it's simply very difficult or even impossible to do what's expected of them without the support of a solicitor, and that raises in those contexts real questions about access to justice, as well as kind of administering those courts more difficult. And within that context, we can see evidence from stakeholder perspective, clients' perspectives, data that CAS Plus, despite not providing legal support or not replacing the work of a solicitor, did make a positive difference both to experiences and to potentially people's capacity to achieve a satisfactory outcome. So I think we can see Pathfinder coming through and certainly seeking to improve the experience of litigants in person. But even in that context, it feels like there remains a need for support beyond what the court is able to provide in Pathfinder, given the sort of sheer amount of time and emotional labour involved in the CAS Plus support, as well as the kind of complexities that they had to get into. So I think we can see a kind of continued need for this kind of support. But I would say that there is a need for probably a more formal definition of the role of support services like this, as well as perhaps more formal opportunities for training and a kind of clearer definition for the roles of coordinators, both in terms of what they can and can't provide, what experiences, knowledge they should have, and how they should fit into the working of the court. But within that, I would say that this does seem to be a really promising model that can be delivered at scale in a context where legal aid provision remains deeply inadequate. And that's obviously not the context we choose, but that is the context in which we find ourselves. So that's that from me.
Thank you so much, Stephen. You have given us so much to think about there. And given what we have seen in terms of that impact for families, for parents, even just following that first interaction with CAS Plus, I wanted to come back to yourself, Steve and Emma, and ask, what are your aspirations for the service for the future?
Thank you, Sophie. My first aspiration actually is to keep what we've got. Some of the issues that Stephen pointed to at the end there, if we had some longer term security about how long the service could maintain, it would help us to be able to build those pillars to take us forward. The second thing is we're not particularly blessed with legal aid centres or law centres in the Southwest, but there is a developing pro bono approach and a law centre opening up in West Cornwall. So we're looking to build those relationships so that we can allow people to access appropriate legal support where they can. I think that would be a really positive thing. And the last one from me would be to be thinking about how we could expand. People and families don't see borders. So the people who live in Taunton, just away from Exeter, many of them come to Exeter Court and vice versa. So an attempt to get something regional, so we had some sort of parity of service in our local area, would be really positive from my perspective.
Thanks, Steve. Emma, was there anything that you wanted to add in?
I think just as Steve's raised, kind of building on our experiences and our shock at the start of how many people across the country were in need of this support, and we've obviously adapted our own system and reviewed that and developed a triage system so we can cater and support more people. But yeah, on top of what Steve was saying, is building that so it's a regional service that can stretch further.
Brilliant, thank you. And we've had another question that has also come in for yourselves as well, highlighting that that we are clearly recognising the value of the pathways of CAS Plus support, but what are everyone's systemic changes that they would like to see in the system to help litigants in person? There's the mention here around increased legal aid, but are there any other initiatives that potentially could be more effective? And I guess one of the other questions that got flagged up as well, just to keep in mind, was the thoughts around how this complements the Pathfinder model that is being looked at within private law. So there's a lot to consider there, but I was going to say, Jude, did you want to come in? And then Steve, Emma, Stephen, if you've got any additional thoughts before we wrap up.
I mean, I think I can probably take both of those together, because I think this model does have a huge possibility to complement Pathfinder, because as Stephen was saying, there are intentional changes to the Pathfinder model, which are some of the systemic changes I would want to see. And they include deliberately trying to be a problem-solving model, adjusting the role of the judge or the judiciary in that, to say we can't leave it to litigants, but it's not fair, it's not just, and it's not effective to say you need to litigate like you had a lawyer, except you don't have a lawyer. So a more problem-solving model, which is what Pathfinder endeavours to be. But also, I think what is so clear from the evidence that you shared today is about that very significant support need that people have. You know, family court proceedings are deeply emotional, stressful, important things in people's lives. And going through that in the context, as you were saying, isn't often people will not have any friends or family who have direct experience of this. Trying to make sense of what's going on without having somebody alongside you to help explain things, but also, as you were saying, Stephen, to do some of that emotional co-regulation work so that you are in the space where you can participate in the best way possible, I think is really important. And I think the changes within the Pathfinder model are really welcome changes, but they're not pretending to be the level of additional support that a model like this could provide. And I think particularly, as you were saying, for those families where you see that high level of need, often on multiple issues, multiple layers of need coming together, expecting somebody to navigate the court process without somebody to go back to re-ask questions of, to have the ongoing support of, is just unrealistic. And so I think this has got great potential.
Thanks, Jude. Did anyone else want to come in on that before I move to the next question?
I would say, in addition, on a practical sense, is we put together some templates at stages. So using the right language so the clients understand what they need, what information they need to add, and standardized templates that are user-friendly for them, that the courts recognise, really helped some of our systems, and kind of, yeah, reducing those number of adjournments, because people know what paperwork is needed and how to complete it. There's a lot, particularly around the Children's Act 1989, that we were translating and explaining to clients to help them.
And thank you, Emma. I'm really mindful that we're coming up to the end of time, and there's been a very interesting question put in that I think might need longer than 2 minutes to answer, but I will just pop that out there. From Emma, how have you managed the nuances we see in private proceedings, such as unidentified domestic abuse and child sexual abuse, that can be labelled as false allegations? We've got just a minute on this, but I appreciate it is a much more complex topic. Steve, Emma, is there anything you wanted to just acknowledge in relation to that now?
So I would, I'll come to you in a second, Emma, but what I was just going to highlight, our status within these proceedings means that we don't see all the evidence. The information sharing, the information we get is what's provided by one party. So for us, it's really key to keep in mind we're getting one person's perception and we're providing help and advice. So we always try to keep that sort of distance and not getting drawn into the emotion of doing that. One of the challenges we get is where everyone or all parties are making allegations of domestic abuse, and then there's decisions being made around legal aid. That's difficult for us to steer through, but we try our best to keep that perspective in relation to it. I don't know if there's anything you wanted to add, Emma.
No, just very much on top of that, just very much focusing on the children and the process of how to present those allegations, and what evidence there is existing. So we need to take a step out, as Steve has said, and just help the process, and for the courts to go through that information further along.
Thank you both very much indeed. Now we have come to 1:30. I'd like to say thank you so much to everyone, Stephen, Steve, Emma, Jude, for all that you have shared today. Miranda has highlighted and pinned the evaluation report, and there was also a request for the Pathfinder evaluation, and I've put those links into the Q&A as well. Today's session is recorded, as we said, and it will be up on YouTube, and you will also have the slides shared around in PDF format later on. So again, thank you so much, everyone. I will leave it for today and enjoy the rest of your afternoons.
Thank you.